Good afternoon. We're going to get started. My name is John Goldberg. For those of you who don't know, I'm the Dean of the Law School, and I am delighted to welcome you all to our first Rappaport Forum for 2026. Today's topic, as you all know, is the fascinating and important question of, quote, the docket that shall not be named, the Supreme Court's emergency orders. As many of you know, the Rappaport series was created in 2020 to promote and model full, vigorous, and civil discourse on complex and challenging issues facing our community, our nation, and our world. Funded by Phyllis and Jerome Lyle Rappaport Foundation, the forum honors its namesake, Jerry Rappaport, who, as a 1L here back in 1946, established the original HLS Forum. I want to thank the Rappaport Foundation for supporting this vital effort to, as Jerry Rappaport once put it, quote, model a process that is core to our democracy, unquote. I also want to recognize representatives of the Rappaport Foundation who are here with us today, including Bernie and Janet Iserkoff, Jonathan Rappaport, and Jim Siegel. Please join me in welcoming them. Thank you so much for your continued support for this really exciting and vital program. I will get out of the way, but before I do, I want to introduce our wonderful moderator, Professor Richard Ray. As you know, Professor Ray is a leading scholar of constitutional law, federal courts, and criminal procedure. Previously, the Elizabeth D. and Richard A. Merrill Professor of Law at the University of Virginia, and also professor at UCLA Law School. He has published numerous articles in leading law journals, including this past year's Harvard Law Review Supreme Court Forward entitled To a Conservative War in Court. Thank you, Richard. Let me also briefly acknowledge our two panelists, and Richard will tell you more about them. Our first, who unfortunately has to join us by Zoom, thanks to Boston's lovely winter weather, is Jonathan Adler of the William and Mary School of Law. And then somehow Kate Shaw had the ability to actually get here from the University of Pennsylvania Carey Law School. Thank you both for doing this, and thank you all for coming. Thank you especially to the Dean's Office staff and Catherine Cronin in particular for making this event possible. With that, I turn things over to Richard.
Okay, wonderful. So as the Dean mentioned, we are very fortunate to have two fabulous, prolific, influential, widely read commentators on the Supreme Court and many issues legal. Just to proceed alphabetically and somewhat repeat the Dean's remarks, we have Jonathan Adler via Zoom, Professor of Law at the William and Mary Law School, author and editor of many books, a contributor to the Volokh Conspiracy blog, and a contributor to many media publications such as the Wall Street Journal. And next to me in person, we're very fortunate to have Kate Shaw, again, the professor at the University of Pennsylvania Carey Law School. She too is a prolific commentator, a co-host of the Strict Scrutiny podcast, a former member of the Obama White House Counsel's Office, and a contributing writer at the New York Times. So I will say that I am a frequent consumer of wise legal commentary from both of these individuals, and so I'm especially looking forward to learning from both of them today. Let's start it off with Professor Shaw giving us some initial remarks.
Okay, wonderful. Thank you to Dean Goldberg and to Professor Ray for having me. This is a really important topic, and I appreciate the opportunity to engage with you all. In recent years, and in particular since Donald Trump took office for the second time, the Supreme Court's work on the shadow docket has virtually eclipsed its work on the merits docket. If not yet in volume, then arguably in impact. Here are some figures that I think bear out this claim. In a recent piece, Professor Steve Vladeck found that during the Supreme Court's 2024 term, the court granted relief in 31 emergency applications. Okay, during that same period, the court handed down 55 decisions on the merits, 31 of which were non-unanimous. So the same number of emergency relief grants as decisions in non-unanimous merits cases, with many shadow docket rulings that were far more consequential in terms of on-the-ground impact. And although there has been a significant increase in focus on the shadow docket, obviously this forum supports that, I think we still pay far more attention to the court's merits docket. Law professors don't typically teach shadow docket orders, even where those orders appear to have significantly changed existing law, and even though the court has recently suggested that these orders are precedential. The imbalance in press coverage remains. Consider the print edition of last Saturday's, I guess probably Sunday here, we got it Saturday in New York, Saturday's New York Times, which announced on the cover in enormous above-the-line font, "Justices strike down Trump tariffs." By contrast, the Times' coverage of last August's shadow docket order clearing the way for the termination of hundreds of millions of dollars in grants to universities and researchers appeared on page A17. These points are anecdotal, but I do think they speak to the enduring gap between attention paid to the shadow docket and the merits docket. And let me now tick through some data that is specifically about the second Trump administration and the shadow docket. Since taking office for the second time in January 2025, the administration has asked the Supreme Court for emergency relief approximately 35 times. This number in itself is astonishing compared to the practices of past presidential administrations. In the 16 years of the George W. Bush and Obama administrations, the SG asked for emergency relief a total of 8 times, so about once every other year. There was a significant increase in the first Trump administration, 41 times, 19 under Biden, and then this astronomical increase in just the last year. But perhaps more striking than the volume of requests is the success rate. So let's look at how these requests have fared. A couple were withdrawn or mooted or held in abeyance. 2 were deferred pending argument in other cases, or in those cases or other cases. In 3 cases, the administration lost, although, in 1, the administration had already gotten the relief it was seeking, and later one very big. I will also count a case people have probably heard of, Abrego Garcia, as a government loss, although the court actually technically granted the government's request that it not be required to abide by an initial deadline, and did conclude that the administration couldn't be required to effectuate Mr. Abrego Garcia's return. It did agree that the administration could be required to take steps to facilitate his return. The administration prevailed in the other 24 cases, and a couple were also arguably mixed results. I won't get too into the details, but even if we set the 2 or 3 others to one side, so 21 or 22 instead of 24, this is a stunning win rate. In addition to the cases I've already referenced, shadow docket grants have included orders permitting the administration to remove individuals to third countries without complying with the Convention Against Torture, to expel transgender service members from the military, to permit roving ICE raids to stop citizens and non-citizens alike. The court did not offer one word of reasoning in any of those cases, although in the case about the ICE raids, Justice Kavanaugh did pen a lengthy separate concurrence. With a few paragraphs of reasoning, so more but only a little more, the court has also permitted the elimination of approximately $4 billion in foreign aid funding, allowed the provision of unfettered access by DOJ to American Social Security information, and permitted the elimination of approximately 1/3 of the Department of Education. Again, this is the court setting aside, either with no reasoning or in orders that were a paragraph or too long, carefully reasoned decisions of lower courts, replete with factual findings to which appellate courts are supposed to defer. And I think that last point is a critical one. I've listed a lot of numbers, but in some ways focusing on the numbers is counterproductive. The frequency of these orders in recent months can numb us to how atypical they are, historically speaking, and also how destructive of core aspects of our system of litigation. And that is whatever you think of the underlying assertions of presidential authority. So in the time that remains, I want to drill down on a few things I think are especially egregious about the court's disposition of these requests over the course of the last year. The first, I think, is the manifest disrespect, shading into contempt for the lower courts that's on display in some of these shadow docket orders. I think that was especially pronounced in an example that is close to home for this Cambridge crowd. So that's in early 2025. Just to set it up a little bit, the administration directed agencies to terminate grants or contracts related to diversity, equity, and inclusion, among other forbidden criteria. A group of grant recipients challenged the terminations that were affected by the NIH pursuant to this order, and Judge William Young of Massachusetts, after a hearing and a bench trial, found that the grant cancellation was arbitrary, or the cancellations rather were arbitrary and capricious under the Administrative Procedure Act. The First Circuit declined to stay Judge Young's order, and the Solicitor General filed an emergency application in the Supreme Court. On the shadow docket, the court stayed part of that opinion with a cryptic one-paragraph order citing an earlier shadow docket order in a Department of Education funding case, and explaining that in this NIH case, like that earlier Education Department case, the lower court had lacked jurisdiction to order the payment of grant obligations. In a concurrence, Justice Gorsuch accused Judge Young of failing to follow the Supreme Court's direction and reminded readers that lower courts are not, quote, free to defy the court's decisions. Gorsuch listed several other district courts in cases he suggested had gone astray, and he purported to remind all of, quote, a basic tenet of our judicial system. Whatever their own views, judges are duty-bound to respect the hierarchy of the federal court system created by the Constitution and Congress. It was, to put it mildly, rather rich to hear Justice Gorsuch accuse other federal judges of conduct inconsistent with the basic tenets of our judicial system. And I know Judge Burroughs spoke for a lot of federal judges when she later wrote that it is, quote, unhelpful and unnecessary to criticize district courts for defying the Supreme Court when they are working to find the right answers in a rapidly evolving doctrinal landscape. So this dynamic, I think, is genuinely new. So the court has made what I think are deeply misguided and sometimes procedurally suspect decisions on the shadow docket before, in death penalty cases and election cases and more. But it is only in the last year that it has also lashed out at district courts for failing to properly implement the rules emanating from its shadow docket orders or for not anticipating the Supreme Court's future moves. And that last category includes a group of cases I haven't yet mentioned about the president's power to fire heads of independent agencies. And of course, it is true that the court has been sending strong signals since 2020 or maybe even 2010 that Humphrey's executor and agency independence are not long for this world. But the court hasn't taken that step yet itself. So when the lower courts, in challenges to these firings, abided by existing law, they found their orders stayed and sometimes derided, and the president given the power to fire immediately. But this isn't just about sort of the etiquette of disagreement. I think there's a more kind of fundamental point here. I think it is profoundly destructive to the rule of law and to basic precepts of our legal system for the court to send the message that it will utterly disregard the factual findings of lower courts if those findings are an obstacle to the result the court wants to reach. And I think that's the clear takeaway from a lot of these orders. So consider Vasquez-Perdomo, the case about the roving ICE patrols. The district court there issued a temporary restraining order in a 52-page opinion describing a, quote, mountain of evidence, including 21 declarations, that ICE was rounding up individuals without reasonable suspicion and denying them lawyers. The TRO just barred ICE from engaging in stops and arrests based solely on an individual's apparent race or ethnicity, the fact that they speak Spanish or accented English, or their presence at a particular location and type of work they do. The Ninth Circuit denied the government stay application in a 61-page opinion. DOJ's application to the Supreme Court didn't even really dispute the allegations that this is what the government was doing. And in issuing its stay, as I said, the court said not one word about where the district court had gone astray. Justice Kavanaugh, in his concurrence, did not say that the district court of the Ninth Circuit had committed any clear error in their factual findings. Instead, he constructed an entirely different factual universe, describing the government as, quote, sometimes making brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs. He continued, quote, if the officers learned the individual they stopped is a U.S. citizen or otherwise lawfully present, they promptly let the individual go. I have read the government's brief in this case. It's possible that that line comes from a regulation, but there is nothing in the lower court opinion, or I think in the record, that supports that description. This has created new and really profound problems for litigators who have long operated within a set of institutional practices in which district courts find facts and neither courts of appeals nor the Supreme Court are entitled to decide factual questions de novo. Factual deference is actually pretty foundational. I think we tend to think of it as grounded in practical considerations about competence and vantage and access to witnesses and evidence, and I think it's all those things, but it is also undergirded by a suite of constitutional provisions and values, from due process to the Seventh Amendment. And the strong signal the court seems to be sending is that it will decide questions of fact itself, but it utterly lacks the tools and resources to do that. Okay, I'm going to take one more minute and then I promise I'll wrap. So we're here to talk about the Supreme Court shadow docket and not to debate the lawfulness of the specific actions taken by the Trump administration in the last year. And I do not want to appear to be changing the subject. But I am not sure we can talk about the Supreme Court and the shadow docket in this moment without acknowledging the larger context of what we're witnessing from the executive branch. And that is an assault on the idea of the Constitution as a set of binding constraints, including constraints on the president. And I think this moment actually highlights the limits of the kind of atomism that sometimes characterizes the way we teach and debate law. So it is understandable that we generally tackle one body of doctrine or one topic at a time, right? Like we're going to discuss the First Amendment or the separation of powers. We're going to debate the shadow docket and not the president's authority to dismantle agencies or refuse to spend appropriated funds or fire heads of independent agencies. But right now, I actually kind of worry that zooming too far in actually does both our students and listeners a disservice. So we can parse individual cases and moves, and as to some, there is definitely room for reasonable minds to disagree about the correctness of the court's actions. But the aggregate effect of the Supreme Court shadow docket in the last year is to affirmatively facilitate the actions and to shore up the authority of a president who is waging an assault on the separation of powers and whose actions, I think, reveal outright contempt for the Constitution, which is a document that, whatever our disagreements about what it does and how to interpret it, and there are many, I think we all believe in. And in this time of constitutional stress, the lower courts have functioned as an important bulwark in defense of the Constitution and the separation of powers. Rather than shoring them up, the Supreme Court on its shadow docket has again and again participated in eroding their authority, and that, to my mind, is more important than the particular demerits or merits of specific moves the court has made on the shadow docket. So thanks for the extra time. With that, I will look forward to the discussion. Thank you.
Okay, thank you. Professor Adler, would you like to make some remarks?
Sure. Well, first, thank you, Professor Ray. Thank you, Dean Goldberg. Thanks to the Rappaport Forum for having me as a part of this discussion. It's a pleasure and an honor to be able to participate and to discuss these issues with Professor Shaw. I'm sorry I'm not able to be there in person, but the airlines or the snow were not cooperating. So instead, you have me, I guess, doing this Wizard of Oz impersonation projected on the wall. And I guess in the spirit of the Wizard of Oz, what I'd like to do, at least in the initial part of my remarks, is to peel back the curtain a little bit about the shadow docket and help us put it in perspective and understand or try to understand some of the structural causes and dynamics that I think cause some of the pathologies that raise concerns and that appear to be unusual and disturbing. And I think that if we understand these dynamics, that can help us form a more informed judgment about what we think about it, and can also serve as a predicate for potential reforms. Now, in terms of the title of our forum, and what should we call this thing? I do think it's worth remembering that the term shadow docket was coined by Professor William Bode as a way of describing all of the court's non-merits work. By some accounts, 99% or so of the decisions it makes about certiorari, about rehearings, about briefing, about time extensions, about all sorts of things, including requests for various types of extraordinary or interim relief. He called it the shadow docket because at the time, we didn't have much of a Supreme Court website. We didn't have access to a lot of information, and a lot of these decisions, with the possible exception of rejections of stay requests for death sentences, was really not covered or discussed at all. And I think as a realistic matter, the fact that we're having this forum, that there's a best-selling book with the title that this issue is discussed so much, suggests that actually much less of this is actually occurring in the shadows. And the portion of this work that we're most focused on, the courts getting requests for interim relief of some sort in pending cases, is, I think, getting quite a bit of attention. And I think it's also worth recognizing that this is something that the court has to do. That is to say, it's hard to imagine a court system in which there is a Supreme Court that has among its responsibilities superintending the lower courts, not having the ability to consider and provide extraordinary interim relief in pending cases. Again, we've long recognized this in the context of death penalty cases, and at various times in our history, we've seen increases of other sorts. And certainly, as Professor Shaw just noted, in the last 10 years, we've seen a dramatic increase in both the requests for interim relief as well as the court providing it. And what's interesting, we saw some of this increase actually occurred before the first Trump administration. We saw a significant increase in court intervention in capital cases. We saw some other cases that may be a bit sui generis, where the court was getting involved in a way it might not have in the past. So, for example, it issued 2 orders related to the Juliana kids climate litigation. And I think when we see why the court was getting involved then, we understand a little more about why it's getting more involved now, which is part of what it does, is consider requests to provide relief to what are outlying or overbroad or unwarranted relief offered by lower courts. And I think that's part of what we're seeing now. But I think there's more than that. I think the sources of the dynamics we're witnessing are, in many respects, structural. And if we remember that the court, especially as compared to other parts of our government, is fundamentally a reactive institution, certainly as compared to the executive branch and the legislative branch, we can recognize that what we're seeing from the court is it responding to dynamics that are occurring in other institutions and throughout our legal system. But what do I mean by that? Well, most obviously, we have had a dramatic increase in presidentialism, what former Harvard Law School Dean Elena Kagan referred to as presidential administration. The dynamics that she described in that famous, very important article have only increased, have only accelerated. Trump was certainly an accelerant to that, but if you just want to trace the trends from the turn of the century, even to Trump entering office, we see that increase, an increase of presidential unilateralism, efforts by the executive branch to take policy initiative that used to be done by Congress, and to the point now where we might say it's hyperactive. And this comes against the background of congressional inaction. And that inaction is not just a lack of engagement with presidents, particularly presidents of the same party of the congressional majorities, but also a failure of Congress to stay in the game of enacting statutes, revising statutes, and the like. I do a lot of work in environmental law. Most of our major environmental laws have not been reauthorized or meaningfully reformed this century. And trust me, the environmental problems we're dealing with have not stayed still. Right? That level of inaction creates a vacuum. The president fills part of that vacuum. And the response is people that don't think they can get relief from Congress or that Congress will respond instead turn to the courts. And that's not just individuals and activist groups, it's also state attorneys general who have become far more active in litigation, especially policy-oriented litigation, partisan litigation, as states arguably have an advantage in terms of being able to invoke jurisdiction, choose forums, and to articulate and push for innovative and entrepreneurial theories, both on the merits and in terms of what sort of relief. We add to that more aggressive forum shopping than we used to see. Right? Opponents of mifepristone didn't randomly pick a district court to file suit in. They picked a particular district in New York, in Texas, to file suit, and they got an order that, had it not gone to the Supreme Court on the interim docket, shadow docket, whatever you want to call it, would have required taking mifepristone off the market. Right here, we had a judicial decision that was an outlier, that was the result of activist litigation and forum shopping that produced an outcome that was going to certainly generate a request for the court to act, and I would argue a request of the sort that we would want and expect the court to respond to. Well, this sort of thing is happening more and more, and it's happening more and more in the form of nationwide injunctions. I'm sure all of you, or many of you at least, are familiar with the great survey of these trends that the Harvard Law Review published. From 1963 to 2023, there were 127 universal injunctions, but over 80% of those are since 2000. There were 6 such injunctions against the George W. Bush administration, 12 against the Obama administration, 64 against the first Trump administration. As you know, Elena Kagan noted in 2022, you add these things together and you get something that structurally is not tenable. The increase in nationwide injunctions and other types of extraordinary relief, combined with the ability to forum shop, especially if you can rely upon activist groups and state attorneys general to help you with that process, you get a situation that, as she described it, can't be right that one district court, whether it's in the Trump years, who used to go to the Northern District of California, and in the Biden years, they go to Texas, and it just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process. So these broader dynamics, to which Trump is certainly an accelerant, have led to an increased demand for Supreme Court intervention. The dramatic increase in requests has meant there are more cases in which Supreme Court intervention is warranted, and the Supreme Court has responded. And I think it's worth noting as well, there have been changes in just kind of the court's view of its role that I think has also made it more receptive to some of these requests. So, for example, going back to the very beginning of the Roberts Court, we know that a majority of the justices have a more skeptical view of injunctive relief against the federal government than perhaps prior courts did. We see this in cases like Winters versus NRDC, the case involving Navy sonar affecting whales. Chief Justice writes an opinion very clear saying, in his view, too many lower courts, or he's saying in the court's view, too many lower courts are too quick to give injunctive relief against the federal government. You would then expect that view to play out in requests for interim relief. I think you also see in the court's majority a view of the court as not an entity that pronounces on the rule of law generally, not an entity that is supposed to be a hall monitor for the executive branch, but an entity that resolves specific cases brought before it by parties that have a right to invoke jurisdiction. It's not a titan to be in this battle against the other branches, but rather an institution that is supposed to play a different role. And I think if you recognize that those are the jurisprudential orientations of the court, it's understandable why it views some of what's going on the way it does. So what have we seen in the Trump administration? Well, there have been, last I looked last night, over 650 lawsuits filed against the Trump administration. And they have not been filed randomly, right? The lion's share of those were filed in DC. The circuit after that with the most cases filed is actually, I was going to say here, but not here where I am, here where you are, the First Circuit. That's not an accident. It's because of the composition of the First Circuit. Of those 650 cases, there have been somewhere in the neighborhood of 150 orders providing some sort of injunctive relief or blocking the Trump administration from doing some of the things that it does. And again, not randomly distributed. Of the first 40 nationwide injunctions entered against the Trump administration, 35 of them came from just 5 judicial districts. Again, not an accident. Prior to CASA, it's also worth noting, there were more nationwide injunctions imposed against the Trump administration than against the Johnson, Nixon, Ford, Carter, Reagan, and Bush 41 administrations combined. Now, whether or not we like what the Trump administration is doing or not, that volume of litigation is producing a volume of requests for relief, which we would expect to produce a volume of responses. But I think there's another factor here that's particularly important. The Trump administration doesn't ask for relief in all these cases. Over 150 orders against it, it's brought fewer than 25% of those it is brought to the Supreme Court. And it's bringing the strongest cases. We can debate why that is, why it's picking, but it's not picking the cases where its legal arguments are nonsense. It's picking the cases where its legal arguments are the strongest, or at least most in line with what it expects from this court. So a lot of cases about core executive power, a lot of cases about jurisdiction, a lot of cases about how certain types of claims should be channeled, and on cases involving the law firms and involving a lot of things relating to universities and a lot of other areas where I think Professor Shaw and I would agree the administration's legal theories are, shall we say, questionable at best. The administration has been more than happy to slow walk those cases. And I think that's why we see this record, this scorecard, a scorecard that the White House loves as a political talking point, but that is very unrepresentative of what the court is doing overall. And I think as last week's decision on learning resources shows that we should be careful about making broad judgments about what this selection of the court's work suggests. I realize I'm running out of my time. My last point I'm just going to say is that we have to recognize in terms of how the court responds to these dynamics, there are some very real and serious trade-offs. The court can resolve more of these cases more quickly and write opinions, but we know those opinions are likely to be less well thought through. They may be more likely to reflect the justices' priors rather than their careful reflection and consideration of the arguments. And so I don't think that many of us, when we think about that as a solution, that actually solves the problem. I mean, it's nice the court's giving us paragraphs instead of sentences in some of these orders, but there are serious trade-offs about asking the court to give full opinions when it's operating on this time frame. And perhaps in the discussion we'll talk about what either the court or Congress could do that might address some of these concerns in ways that still respect the role of the court in our structure. But I've gone over time and I will stop there. Thank you.
Great, thank you. Perhaps we could pivot to a prescriptive discussion, and building off the trade-offs that Professor Adler was just mentioning. And so I guess for Professor Shaw, that comment may be more tilted towards instances where this kind of judicial decision-making is appropriate, and Professor Adler next maybe tilt towards finding out instances where, despite your remarks, the Supreme Court is providing this relief too much. So Professor Shaw, would you like to start us off there?
So just kind of broad reform and thoughts. Yes, I mean, to confirm some kind of embedded premise, no, I definitely don't take the position that it is categorically impermissible for the court ever to act in kind of an emergency posture. I mean, it's definitely right, as Professor Adler was describing, that this is not a new phenomenon. Obviously, the numbers that I was just describing are new, but the court has long been asked for and has occasionally granted relief of various sorts outside of its ordinary decisional processes for full briefing and argument, et cetera. And I agree with part of what Professor Adler said, that there are risks in the court, offering hasty written opinions to accompany these orders. That's a point that Justice Barrett made a number of times in interviews about her books, or about her recent book when she was asked about this. Well, we don't want to commit ourselves to positions that haven't been fully kind of ventilated, and so it's better to say less than more. And I think if the court is in that position, it should not intervene. If it is not in a position to offer reasons to support its decisions, then except in the most actually extraordinary circumstances, it should do nothing and allow the carefully reasoned orders of lower courts to stand. So I think that, as opposed to issuing unreasoned orders, is the better option if the court is, kind of weighing these costs and benefits. I mean, I do think that the court is at historically low merits cases numbers, and it could easily convert these set these shadow docket requests for accelerated argument, and it can do this, and it has done this, sort of moving things from the shadow docket onto the merits docket, or just setting for argument shadow docket orders. The initial procedural challenge to the birthright citizenship executive order, or the lower court, dispositions of that order in the CASA case, that TikTok argument from just after, or from a little over a year ago. Obviously, the tariff case that Professor Adler alluded to was expedited. I mean, the court is very capable when it wants to of moving quickly. So I think that, and also it could use a little more work, actually. Like 55 merits decisions in a year is pretty low historically. And I mean, I guess if you're me, you don't love much of what the court is doing substantively, so maybe that's not something you should wish for. But they're going to be resolving these cases, and I would much rather, as an institutional and rule of law matter, have them do it in a more responsible fashion. So more argument, more written decisions, even if I disagree with the bottom line outcomes and reasons, I think would be far preferable to the current state of affairs. Let me say a couple more quick things. One, I think, voting requirements are worth thinking about in these shadow docket orders. So one thing I have thought about, so summary reversals, which, as Professor Adler mentioned, the shadow docket itself can, encompasses a lot more than just these emergency applications for stays and sometimes these injunctions pending appeal. But it's, summary reversals, it's obviously statements respecting denials of cert, it's, the orders list and everything on it. But summary reversals, by kind of custom, require 6 as opposed to 5 or 4 votes. And I don't know that requiring 6 as opposed to 5 votes in some of these shadow docket orders would be a bad development for the court to consider. And I guess I'll say it more affirmatively. I think that would be a good thing for them to consider. So voting requirements, and then thinking about how they articulate and actually use the standards, both again for injunctions pending appeal, which are in some ways the most aggressive of what they do on the shadow docket because they're enjoining a policy that no lower court has enjoined, versus most of what they've been doing, which is these stays of lower court orders. And it's not always clear if the court is using the same or a different test between the two, but either way, the injunctions I think should require the most kind of heightened showing, but not an impossible one to satisfy, but they need to tell us and then show us.
Great, thank you. Professor Adler?
Yeah, so I mean, I agree with some of that. I mean, I certainly agree the court should take more cases. I don't believe that the court takes all of the cert-worthy cases in the petitions. I think that, insofar as culturally there may be a disincentive to the recommending of cases for certiorari in the cert pool by the clerks, that's something that perhaps the court might want to address. But first, in terms of focusing what the court can do, because I think there's a separate question about perhaps what Congress can do. I do think that on the one hand, the court has been taking some of these cases on an expedited basis. I do think the court is reluctant to do that, and I think we would regret doing that across the board for every high-profile, monumental question related to some executive branch initiative that a district court has decided is problematic. And because I think we would lose a lot of what I think we generally value in appellate review, especially at the Supreme Court level, which is percolation, which is the ability of the justices to be able to take their time and really think through the cases and not just make a quick judgment based on their priors and then write as persuasive a justification for that as they can. And I worry the more we condense the process, the more we get some of the latter. So I do think, in addition to what the court's already been done, I do think there are things the court can do that might alter some of these structural dynamics. I think its ability to do that is somewhat limited. I think Congress probably has to do more there. Not that any of us knows how to make Congress do anything, but I do think that's where the bigger solutions lie. But certainly if the court were willing to say more about remedies, even when it thinks it's unnecessary, that would be helpful. So just look at the nationwide injunction question. The Bush administration asked the court to say something about the inherent authority of courts to issue nationwide injunctions in the Summers versus Earth Island case, 20-some years ago. Court didn't. Why? The same reason it didn't when asked by subsequent administrations, because the court would accept the case on the merits. And then once the courts decided the merits, the nationwide relief issue is moved, right? Because the court's judgment is nationwide. So I think the court, recognizing that if lower courts have been dealing with remedies issues, especially about interim remedies, saying more about that, even if it thinks it's unnecessary, I think would be helpful because that would give lower courts more guidance on that sort of question. I think that the court could think about whether or not it's made it too easy for certain types of parties to sue. Right? Special solicitude for state standing was probably a bad idea. I also happen to think it was completely made up. But I know there are scholars that don't think that that doctrinal move is actually responsible for the increase in attorneys general litigation. But I do think the court could try and have litigation more driven by people that have actual complaints rather than by political entities that have their other agendas. I think there are things the court could also do that would make it lower the stakes for the executive branch. One idea that I'm not sure I like as a normative matter, but certainly would reduce the irreparable harm to the executive branch of an injunction would be, for example, enforcing Vermont Yankee more stringently. What I mean by that is taking seriously the idea that the process that agencies have to provide is only that which is provided by statute, and courts can't impose additional procedural requirements. There are lots of things that we require agencies to do that it's not clear we can really say are based in the Administrative Procedure Act. And as a normative matter, I'm not sure I like that, but if the goal is to lower the stakes so it's easier to deny relief to a presidential administration, that kind of reform would do it. One that I do like normatively, and I think one of three people that takes this position, is recognize that the Administrative Procedure Act doesn't authorize universal vacator. And that, I think, would also lower the stakes in some of these cases. And if the stakes were lower, I then think you get fewer requests. The court doesn't have to make decisions. So I think those are some of the things that the court could do that might help on the margin.
Great. And I'll ask one more question before we open it up to the audience, because I think we're all keen to get the audience's thoughts as well. But the title for this event, the docket that shall not be named, the brainchild of our own Professor Brady, I might say, I think is a really nice entry point for figuring out why is this hard to name? What's at stake in the name? Does it matter? Is it just a sign of how things have changed, that there isn't a better name? And so I'd be really curious to hear each of your thoughts on that, Professor Shaw.
Sure. Well, look, I mean, I think naming is powerful and it's also kind of inescapably normative. So I get that we're sort of focused on it. I think the justices obviously care what we call it. Justice Alito, a few years ago, kind of referred in remarks to the, quote, catchy and sinister term shadow docket that's used to portray the court as having been captured by a dangerous cabal that resorts to sneaky and improper methods. So like, yeah, he thinks it's pejorative. So, I mean, I think shadow docket is evocative and useful. And also is a little inaccurate if we're talking just about the kind of emergency docket that has been the focus of our conversation today because it is broader. And I think I am fine with either of those. The interim docket, which is something that Justice Kavanaugh has floated, I think is kind of affirmatively misleading in that, and maybe not intentionally, I don't want to ascribe sort of bad faith, but for a reason that I think is well captured by something that Professor Kim Lane Shepley wrote pretty early in some of the litigation around the Trump administration's actions. So I'm going to just, if you'll indulge me, read just a couple sentences. She writes, quote, "Think of the executive branch before January 2025 as an aquarium in which agency fishes are swimming around acting like a government. Trump inserted a blender into the fish tank because he asserted he has the constitutional power to create fish soup. It matters if the court allows the blender to be turned on while it decides the legal question of whether the Constitution permits the president to make fish soup." So that, I think, really captures why interim isn't an accurate description, because the status quo the court announces in these orders is not interim in any meaningful way for many of the actions. And I'm talking specifically about the kind of executive branch requests for intervention. Again, I was just really talking about those in the second part of my opening remarks. States have asked, and affected parties have asked occasionally in the last year for the court's intervention. And maybe there's an argument that some of those grants of relief are more interim. But I think when it comes to many of these kind of unringable bells that the administration is seeking. Sorry to mix metaphors there, but it's. I think interim is inaccurate, but I do think that that it says something that the justices are clearly as concerned as they are with how we talk about this, and I think that the kind of public pressure, although I think there should be more of it, we're seeing sort of manifest in some of the kind of agonizing over what to call it. And I think that probably that would be better spent kind of focusing on substantive reforms to what the court is doing.
Terrific. Professor Adler?
Yeah, I mean, I guess I'm more comfortable with the phrase interim docket. I would probably call it the interim orders docket, because I think that's a better, and that makes clear that we're talking about orders that are interim within the context of litigation, not necessarily in the world. I think the reality is that when these requests come in, there are things that are irreparable and that can't be changed on both sides. Now, the court believes, and this is a controversial view, but the court believes across the board that injunctions against the executive branch necessarily impose irreparable harm. And I think that is informed in part by the idea that the executive branch only has a particular amount of time to advance its priorities. And if the litigants or others can run out the clock and prevent things from happening, then the executive branch doesn't get to do what the executive branch should be allowed to do as a result of elections. And I think it also feels that the primary pushback should not be from the court, but from the legislature. And if the legislature is sleeping on its job, that Marco Rubio can have 20 jobs, but I think the court just wants to be a court and doesn't want to take Congress's job of oversight of the executive branch. So interim orders doesn't bother me. I think my thought about the shadow docket, again, I'm not worried that it's unnecessarily pejorative. I'm just not sure that it actually captures the dynamic anymore, because we spend so much time talking about and focusing on this part of what the court does. And interestingly enough, there are things that were part of Professor Bode's original description of the shadow docket that we still don't talk about very much, that might matter. So calling this part the shadow docket, I'm not sure it's particularly informative or descriptive, but I'm not gonna go to the barricades on what title we give it.
Okay, great. Do we have any audience questions? Please, right here. I think there's a microphone coming to you.
Hi, professors. Thank you so much. This has been wonderful. I was wondering if it's, so my understanding is that for the first 100 years or so, we had opinions that were very, very short, not super in-depth reasoning. So do you think it's possible to view something like the interim/shadow/emergency orders docket as actually a return to some sort of normalcy at the beginning of the founding, and something like learning resources with 170 pages of academic discourse about the intricate nuances of methods of interpretation, as the aberration?
Professor Adler, would you like to take a first stab at that?
So that's an argument for taking away their word processors and their clerks. I mean, look, there are old opinions that are also ridiculously long, right? Print out all of Dred Scott, print out all of Myers versus United States. I mean, there are some old cases that are doozies. Um, I I think what's really different, and Professor Shaw mentioned this before, right, is the court heard a lot more cases. And one thing I'm not sure either was brought up is one reason for that was prior to, I guess it was Chief Justice Taft, and then the court had a much larger mandatory docket that was mandatory appellate jurisdiction. Taft began the process of whittling that away, and I think eventually it was whittled away to almost nothing, I guess, in the 1980s. And that's really the big change, right? In the sense that the justices decide, 90% of their docket, 95, other than like an occasional election-related case or the occasional original jurisdiction, dispute over rivers or something. Every case the court takes, it's because they wanted to take it. And there are virtues to the certiorari docket, right? Being able to figure out what's the right vehicle to address a particularly persistent or important question. But I think it results in the court hearing too few cases and not being as responsive. And I think that it having more cases would mean they would get better at writing opinions much more like the chief's opinion in learning resources than perhaps much of the rest that was issued last week.
Yeah, I'll just say, so yes, I think something between learning resources, although I was going to say the same thing, the chief has actually got a pretty svelte, like 20 pages in his opinion, but obviously the concurrences go long. Something between that and sure, dismantle the government, go ahead, like might be the sort of like happy medium. And I also I appreciate that Professor Adler has said repeatedly, and I think this is something that I also just kind of want to underscore, Congress is really kind of critical here, and that doesn't really speak to the kind of length of opinions issue, but in terms of, right, before 88, the court had tons of mandatory jurisdiction cases, and, I'm not quite sure like what my ideal legislative package looks like, but I do think that Congress has gone way too long without any kind of substantive exercise of its authority to regulate jurisdiction, and it should kind of get those muscles working again.
Okay, we have another audience question. Please.
Thank you so much. I guess my question is, to what extent do you think that emergency orders are being used to sort of send a signal to the lower courts of, actually, we want you to go this way, we want you to go that way, or we don't want you to talk about this, or to sort of have that function of, I think you quoted someone saying that it was inappropriate to sort of tell off the lower courts in that way, but actually the extent to which they are fundamentally operating in that way, and as the Supreme Court telling the lower courts what to do without having to do all of that pages of reasoning.
Sure, yeah. I mean, I do think that the court is, putting kind of an impossible task to the lower courts, which is to sort of, divine the actual kind of contours of the directives that the court is giving the lower courts without actually the court writing much. And I do think this is maybe a little beyond the question, but something I did want to say. I do think that in terms of the court seeming to assert it's kind of this de novo authority to find facts. And maybe that's not the only way to read what the court is doing, but it may think the lower courts have just fundamentally made a hash of the legal standards or their application, but we just don't know. And the little signs that that we have to go on do, I think, to me, suggest the court is functionally, if not formally, asserting the power to kind of decide facts de novo. And that, I think, has a very real effect on appellate courts, which I think feel emboldened to do the same thing when it comes to district courts and their fact-finding. And again, I just think there are real kind of rule of law concerns about that. But yes, I do think that the court is, and sort of has said almost as much, sometimes in kind of comments on earlier orders that it has issued, that it thinks it's sending pretty clear signals to the lower courts about the way it is likely to go up in the kind of the president's power to fire cases. Kind of in particular, the court sort of chastised the lower court for not understanding that it should have, the lower court should have allowed the president to immediately fire the head of the Consumer Product Safety Commission after the Wilcox order, which was an order about, not the FTC, but the EEOC and the NLRB and the president's power to fire commissioners on those bodies. And so, I think it's requiring a lot of lower court kind of like anticipatory ruling, like what did the court mean and what will the court rule? And I just don't think that's any way to run a railroad.
I mean, I think the court is sending trying to send a message, but I think Professor Shaw and I would agree that it's easier to send a message if you actually write the message out. It's certainly more communicative. I mean, and we've always seen this, right? So in the early aughts, or throughout the aughts, we saw a large number of summary reversals of the Sixth Circuit in habeas cases. Right, so these were they would accept instead of accepting the cert petition and scheduling for argument, they would just issue a per curiam opinion saying, yet again, you guys are misapplying EDPA. Right? Whoever's view of EDPA you liked, it was clear that the Supreme Court's view was the Sixth Circuit was out of line with its approach and repeatedly, and it was sending that message. I think given the press of time, it's harder to do that, and it's especially harder to do it in a way that you're going to get everyone signing off on. But I do think that is part of what the court's doing. I happen to think that the court is not second guessing the facts. The court thinks that the lower courts are making errors of law or providing remedies that are either inappropriate or not authorized. I think that's what we saw in the nationwide injunction case. I think we see that in a lot of the orders. And I do think it is fair to say that in at least some cases, the court has given enough of a signal that lower courts have ignored. I think if one goes and looks back at the Wilcox order, right, the court has a few sentences saying, well, this is why we think the balance of equities come out the way they do. And even though it was only a paragraph, I think that's enough for a lower court to engage with. And if the lower court with a different agency didn't engage with it, I think the court is, it's okay that the court is a little frustrated. On the other hand, I think Professor Shaw and I would agree that in the case where Justice Gorsuch wrote that separate opinion, didn't seem to me to be the right case to pick that battle, because that's the 414 case. And if the Supreme Court's 414, I'm not sure that's the case to say, lower court, you're not listening. I think the place to say lower court, you're not listening might be, from Wilcox to Boyle. But I think, as I noted before, if the court wants lower courts to get a message, at some point is going to have to be more explicit about what that message is and what that means. And that might even mean, in merits opinions, spending some time on things that justices may not want to think about, like what does this mean for remedies and interim relief in a district court? And there are only two justices that have ever been in that position. And so maybe they just don't recognize why it's important to talk about that. But it probably is important to talk about that.
Okay, can we get a third audience question? Please.
Can you hear me? Okay. Hi. Thank you both for being here. I'm wondering, this is maybe a little more fun and less doctrinal. I'm wondering if you have a sense of whether you think a critical mass or a majority, or perhaps the conservative majority on the Supreme Court is happy with the way that this shadow docket emergency orders thing is working. I think that there's the entire legal left is screaming their heads off about this, and I think there is this sense that actually everything is working as intended, or this is a feature of the system, not a bug. The emergency docket and the procedural discretion and these things that the Supreme Court is able to do is all this is set up to enable this kind of action. And that's a very leftist view of the way that this is supposed to work. But I'm curious, especially from you, Professor Adler, is this something that there actually is bipartisan appetite for reform on, or should there be? Or is it, in fact, that we should think, oh, well, the Supreme Court justices are happy, this is how they want it to go?
Professor Adler, why don't you start us off?
Yeah, I no inside information here. I don't think the justices are happy. I don't think they like the time pressure. I don't think they like the volume of these. I don't think they like the broader political overtones. I think they much more okay, let's take our time, let's hear an argument, let's spend, let's get the opinion right and so on. So I definitely don't think they're happy. I mean, even, and Professor Shaw, may have thoughts on this in the sense of even back when there were lots of capital cases, you talk to people dealing with it, that was not the part of the job that people thought was great in terms of the amount of time it takes and so I don't think the justices are happy. Are other political entities happy? I don't know. I mean, I do believe the White House loves the talking point about its win record. Mm-hmm. And I suspect that one reason why the White House has allowed the Solicitor General to not be more aggressive in putting more cases before the court is because the Solicitor General has been able to say, if you want this winning record, you have to let me be selective on what cases I bring. I'm fairly confident that dynamic is going on, and the White House likes it. I think the president's remarks last week suggest that as well. Congress, I really don't know. And I mean, Congress, if it had any self-respect, would not be happy because the court is inconsistently and incompletely monitoring and in the position of protecting legislative prerogatives where the legislature is absent. So now, whether the Republican majority is like, oh wait, well, this means we can spend more time, on social media and less time actually doing our jobs, then maybe they like it. But from a structural standpoint, a lot of the cases that I think that the administration has won that cause people concern are really cases where the interest that is not really represented is that of the legislature that enacted these laws, that appropriated these funds, that created these structures, and that has lots of tools to reinforce or affect, the consequences of what the president's doing. And at least as far as I can see, there doesn't seem to be much interest in it. So they might be happy, but they shouldn't be.
Professor Shaw.
Sure, and maybe I'll answer that also by, I wanted to just offer a kind of alternative. So Professor Adler talked about like explanations for sort of how we even got here. And there's, I think, a lot of truth to the kind of inert Congress, more executive action, new limits on class actions, which I think Professor Adler didn't say, but that those things together have produced more nationwide injunctions, and so you have more requests, and that's kind of how we got here. But another very plausible explanation is you just had a changed composition of the court beginning in 2017, which is when you really see the trends emerge, and a little bit earlier in the Clean Power Plan is 2016, but you have Justice Gorsuch and then Justice Kavanaugh, and then really a surge, not in the federal executive power cases, but the state COVID restriction cases in 2020 when Justice Barrett replaces Justice Ginsburg, and you just have a majority or supermajority to implement a very long wish list, and we know that majorities are fleeting, and so strike while the iron is hot. So if the conservative majority or supermajority has gotten a lot of what they would like on the shadow docket in shoring up executive power and in shoring up their own, maybe a PR hit is actually kind of a small price to pay. And so I'm not sure they're unhappy, although maybe I'll end by agreeing with Professor Adler, but they obviously, I think, in my view, they should be.
Okay, Professor Adler, would you like to make a final remark for us?
Oh gosh. Well, I'll just say, we've said one thing that we haven't said much about is really what Congress can do and should do, and I think there's a lot there. But as a result of prior legislative choices, the court is, in some respects, less regulated, less constrained, less directed, as is provided for in Article 3. Right? Article 3 gives Congress the power to regulate the federal judiciary in various ways. And we've been now in a period where Congress has done relatively little of that for a long time. And I think that there are reasons to suspect that what we're seeing is partially a consequence of that. And that Congress might want to think about things like, do you require a special three-judge panel for cases where they're seeking nationwide injunctions against the federal government, the way we do in some election law cases? Do we expand the use of things like the multi-circuit lottery to a broader array of cases as a way of limiting the effects of forum shopping? We've already talked about increasing the mandatory appellate docket. Do we do more in statutes to channel litigation, right? So there are statutes that prevent forum shopping by deciding that certain sorts of cases are going to be litigated in particular places, right? So all nationwide Clean Air Act regulations have to be
Well,
challenged.
just so we can wrap up in
these
a timely fashion, I'm sorry to interrupt. Professor Shaw, would you like to give us our closing observation?
I'm just going to give Elena Kagan the mic drop, which is her dissent in the SB8 case. So that goes back nearly 5 years. And I think she was really alarmed about where things were then. And I think things have only gotten more alarming since. So I'm going to quote her. She says, quote, "The majority's decision is emblematic of too much of this court's shadow docket decision-making, which every day becomes more unreasoned, inconsistent, and impossible to defend. I respectfully dissent." And that's 5 years ago. I mean, I shudder to think what things could look like 5 years from now if serious reform is not implemented. And I guess on that pessimistic note, I'll leave it.
Well, I would like to end on a more grateful note, at least, which is thank you to both of our panelists very much for being here and sharing your thoughts.
Thank you.